All right, good morning, everyone. We'll give everyone just a couple of seconds, maybe a little bit to get in before we get into the content today. So we'll just start in 1 minute. All right, beautiful. We might kick it off. A big hello. Thank you, everyone, for joining us today from wherever you might be located. We do have a fair bit to get through, so I might just jump straight into it. So thank you so much for taking the time to join us for today's session on employment essentials, compliance basics for Aussie SMEs. For those that don't know me, my name is Annie, and I am the manager here for the HR advisory team at Employment Hero. And I am joined today by one of our brilliant HR advisors, Lorna. Hi, Lorna.
Hi everyone, I'm Lorna. Welcome, and we're very excited to go through today's content with you.
Brilliant. All right. Just a bit of housekeeping before we get going. There is quite a lot to get through, like I said. So any questions, if you have any questions about anything we covered today, please feel free to use that Q&A function to send that through to us. We will be monitoring this throughout the webinar and hopefully getting to a couple at the end. We do have a very ambitious agenda today, so we'll try to get to a couple at the end. So if you have any burning questions about today's content, please feel free to put that in the Q&A for us to have a look at. Just a quick disclaimer though, we will only be able to answer general questions or give general advice today. So if you have a need for advice for your business or any specific HR questions, maybe reach out to our team and see how we can help you outside of our session today. Now, finally, if we do miss your question or you have to dip off early, please do not despair. We will be sending through a recording, FAQ, and some resources as well, so you can catch up on that content a little bit later. Now, without further ado, let's take a look at this agenda. For today, we're going to be covering quite a fair bit. So first, we're going to look at the Fair Work system in Australia and how this is set up. The 3 different employment types you might want to employ and how to leverage these. The various entitlements under the NES. Then finally, closing out, we're going to have a look at the importance of modern northern classifications and contracts and policies. And hopefully, again, getting to that Q&A if we have some time. So throughout today, Lorna and I are really aiming to give you all the tools and information that you need to navigate the most fundamental areas when you're bringing on a staff member. These basic areas kind of form the cornerstone of compliance in your business and are really essential to get right if you want to be compliant. So we're really giving you a HR basics crash course today. So whether you're thinking of hiring your first staff member or maybe reevaluating how you already employ some staff, the session should hopefully give you a really good kickstart on where to actually start. Now, getting into our first point, which is around how we've set up or how the setup of legislation is in Australia. So the first step to understanding your obligations is to understand how employee entitlements and that Fair Work system is set up. Now, there's a lot to say on this topic alone, so I'm going to keep it to the real basics you need to be aware of when you're dealing with all these different points of legislation. This is something I find clients get very confused about, which is why one piece of legislation can say one thing, and another can say something else, and that can mean, different entitlements for their staff. As a bit of an example of this, as many are aware, the Fair Work Act sets out an entitlement to 4 weeks of annual leave for your permanent employees. So that might seem pretty straightforward, and many clients operate on the proviso that that's just how it is for all employees. However, something you might not know is if you had nurses under the Nurses Award, there is actually an entitlement to an additional week of leave, so 5 weeks per annum. This takes precedence over that Fair Work Act minimum, so it means that those businesses in that situation need to be accruing leave at a higher rate, and kind of paints a good example of exactly why you need to understand the different points of legislation so that you can get your employees' entitlements right. Now, to understand how employment law is actually set out in Australia and why that example of the Nurses Award is how it is, we like to think of legislation as a sort of pyramid, as we have set out on the screen. But as you can see at the very bottom, we have the Fair Work Act, and that's the very foundation of entitlements for employees in the national system. This is the very minimum. Then on top of that, we have modern awards, which are specific agreements for certain industries or roles. Some workplaces might have their own agreements called enterprise agreements or EBAs. However, both of those kind of build on top of the Fair Work Act and provide even greater rules or entitlements and even obligations on how to employ those staff members. They can pretty much provide for most things like overtime, hours of work, penalty rates, allowances, or as we saw before, some awards have leave accruals as well counted for it. Finally, at the very top, we have employment contracts again. This adds another further layer for our employees, both on top of the Fair Work Act and modern awards, usually meant to be more specific to your employees' engagement and your workplace. Now, what I think is the most important thing to understand is that each of these building blocks are meant to add on top of what came before, though what they can't do is undercut the entitlements that came before it. What that means is you can provide for greater entitlements than, say, what the Fair Work Act or the Modern Award has, but you can't provide for less than that. And that's the case even if your employee agreed to it or they signed a contract and said that they were happy with that arrangement. So to paint this example, keeping with what we had before, we know the Fair Work Act had that 4-week minimum or 4-week annual leave minimum. We then had Nurses Award have 5 weeks. If a business wanted to, they could have 6 weeks in their employment contract, but what they couldn't do is just not honor the Modern Award and have 4 weeks, or just have all their employees agree to 2 weeks instead. Now, understanding how the employment legislation is set out is kind of the key step to beginning to navigate your obligations when you want to bring on a staff member. These form the backbone of what entitlements and pay and benefits your staff have to receive, which of course is going to be super essential for then knowing what you have to offer them in terms of a salary or what hours of work you can actually roster them on for. Now, admittedly, this is a very tricky area for you to kind of navigate, but taking that approach where you kind of informally have staff and just bringing them on with an employment contract and a salary offer without having any reference to that legislation is going to be significantly risky. We're going to go through this in a little bit more detail, so touching on modern awards and classifications, but what's important to keep in mind that there is quite a lot that underpins your employees' entitlements and how you have to employ them. So we're going to go through this step by step. It's a bit of a guide on how you navigate bringing on a new staff member or how to audit your current setup. So hopefully you have a much clearer understanding at the end of this session of where to begin when you're addressing compliance and the sort of key areas that you need to be aware of. So the first step, after you know employment legislation, you kind of have a general idea of how that applies, is to then decide exactly how you want to employ that staff member. This is going to have an impact as well on things like the hours of work that they can do, their rate of pay, or even what leave entitlements you need to account for as well. This discussion around how you want to engage them, of course, should happen before they start with your business and as part of the negotiation of their contract terms. And it's quite important because, as I mentioned, it will determine what you're agreeing to. Under the NES, we have 3 main types of employment. We have full-time and part-timers, they're your permanent employment types, and casuals. So each of these have different obligations and can be utilized in different ways and respond to different kind of operational needs that kind of underpinned the hiring need. On the screen, we have a bit of a summary on each of these, but we'll go through a bit of a key difference of all these, see how you might apply them and what might be best for you. So let's tackle the first one. We've got full-time employees, typically work 38 ordinary hours per week or in line with your relevant modern award, which might have an averaging system. They do receive paid leave entitlements like annual leave and personal carers leave and are eligible for things like notice and redundancy pay if that's relevant to them. We then have part-timers, again, another permanent employment type, very similar to full-timers. They work regular hours, of course, but typically less than 38 per week. That's the key difference between the two. They do receive the same kind of leave entitlements, but these are proportionate to the hours that they work. And they also receive things like notice and redundancy pay when they're eligible too. One thing I wanted to kind of particularly touch on with these part-timers is modern awards really do have specific rules, or very often, have specific rules around how you engage your part-timers and can have very strict terms around what you have to agree to. So things that are often found are things like set hours, shifts of work, break times, that can all be set out and you have to have it in your agreement. So very important with your part-timers to make sure you have a look at their modern award. Now we can move on to casual employees, probably the one I see people struggle with the most. And no wonder it's seen a lot of change. It is a harder one to navigate. They're very different engagement type to your full-time and part-time employees. They don't have guaranteed hours or ongoing work, which means unlike your permanent staff, set hours aren't a feature that I would find in their employment contract. Generally, they're not going to get paid leave entitlements, some minor exceptions to that for long service leave and family and domestic violence leave. And they don't get things like notice of termination or redundancy pay as well. Now, casual staff, and I think why they're particularly confusing, have seen a lot of change over the last few years, most particularly with the Closing Loopholes Act that came into effect, or that was talked about a lot in last year as well. We do get asked about these regularly. We won't be able to go into much detail or extreme detail on these changes today. They're very comprehensive. We do have a number of resources that will go over these changes. So if you need any information about these, please reach out. But we're going to do a bit of a recap of what might underpin the casual engagement, just so we're all aware of it. So some of the major amendments that came into effect were a new definition for casual employment in the Act. The most predominant aspect of this definition is the emphasis on the practical reality of your engagement. It is still characterized, as it always was, by an absence of a firm advanced commitment to ongoing work. But what this test really looks at is not just what the contract states, but how you both acted in practice and any kind of mutual understanding that agreed between both parties about how it's meant to act. What that means in simple terms is it's no longer just what was in your contract, and contract might say that they're casual, but if in actual factors and practical reality they didn't act like a casual, what that might seem is perhaps they had regular hours of work, or they couldn't actually just decline work freely, they're not likely going to be a genuine casual. This change specifically was meant to address, or I think attempted to address, these employees engaged as sort of pseudo-permanent staff where they were rostered and acted like a permanent employee, but lacked the entitlements behind them. So more important than ever to kind of think about how you wanted to engage those staff. An important point on that is that casual staff can actually request to move to permanent employment where they no longer meet that definition. So say they're engaged as a casual genuinely, and that was how it kind of started out. But over time, as they operationally were rostered and showed their skill set, they moved to like a regular and systematic pattern. If they have been employed for at least 6 months or 12 months for businesses with less than 15 employees, they can then request to move to permanent employment under what is called the employee choice pathway. This was introduced last year. It did replace the previous casual conversion rules. So we've always had casual conversion, at least for the last few years, but this is a new pathway to that. These rules apply for staff hired after the 26th of August 2024. For anyone hired prior to, there are transitional arrangements that are in place that you probably need to be aware of that impact how they are able to move to permanency. The importance of both these changes is to really consider, I suppose, the type of engagement you are offering staff, and that this is reflective of the genuine needs of your business. So thinking more so than just what is going to be easiest for you to manage. If you think from the outset that you need someone who is working very dependable hours and has set shifts, and you need that assurity they'll be there all the time, probably a permanent engagement from day one is going to be more relevant. On the other hand, if the business can't commit to hours, wants that freedom to change them as they operationally need, or has very high variance in what they can offer, casual employment is probably going to be more appropriate. Now, an aspect very often overlooked, and it pairs with why you need to know what employment type you're offering, is that there are mandatory documents you have to give them when they start. First off, we have our Fair Work Information Statement, which you have to give when they start or as soon after. This is kind of a guide to employees on the basic entitlements and rights they need to be receiving, just to make sure that they're well aware of what they should get as a minimum for their employment. Covers a number of areas, so things from the NES to modern awards and obviously termination entitlements. I've got a full list on the screen, but it's very comprehensive. We also have casual employees that need to receive a specific statement to them, and that is called the Casual Employment Information Statement. They need to receive both at the same time. This goes through the specifics of casual engagement, so things like the casual definition and also the casual employee choice pathway. Keep in mind that the rules around that casual statement did change with the Closing Loophole Act, which made it a lot more onerous and means that you have to give it not only at commencement, but periodically through their employment to kind of remind them of their rights and entitlements to that permanent pathway. So for small businesses, you need to provide this on commencement. You also need to give it at their 12-month anniversary. For businesses with more than 15 employees, a little bit more onerous. You have to give it on commencement, 6-month anniversary, 12-month anniversary, and every 12 months thereafter. So got to keep on top of that. A little bit more onerous than it was previously. A relatively new addition to our statements is the fixed term contract information statement. Again, specific to fixed term employees, it goes over some of their specific engagements. So things like what is a fixed term engagement and disputes and how to resolve disputes about fixed term engagements. Keep in mind, these documents are all mandatory and an employee has to receive each one that's going to be relevant to them. So that means, for example, or theoretically, you could have a casual that's a fixed term employee, means they have to be receiving 3 statements when they commence. So fair work, casual, and fixed term. They have to receive all 3. All right, so we've gone through all the points of legislation. We've covered employment types. Hopefully at this point, you're feeling a little bit more solid about how you want to engage that staff and what might be suiting your business needs best. But an important part of making that decision is to know what other entitlements you need to account for, because there's a number of things that can arise. We're going to take a look at the National Employment Standards, also known as the NES. We'll go through these in a bit of detail so you know what you have to provide for. I'm actually going to pass over to Lorna and have her jump on and go through these and outline what we should be keeping in mind.
Thanks, Annie. Hi, everyone. So I'm going to be taking us through the National Employment Standards, which are referred to as the NES. As discussed in the intro and previously mentioned, they're the minimum entitlements for employees in Australia. The list of the minimum national employment standards are being shown on screen. So there are 12 key areas ranging from leave to termination entitlements. We'll go through these in a bit of detail just to ensure you're fully across each of these, although I know Annie has given a review over a couple, so we'll just touch briefly on those. So first off, we have the maximum weekly hours of work for employees. The NES notes that an employer can't require an employee to work more than a certain number of hours each week, unless reasonable. The factors to consider for this are being shown on screen. For full-time employees, the maximum is generally 38 hours per week, unless their award or enterprise agreement states otherwise. For part-time employees, it's generally the number of hours they've agreed to work in a week. When counting weekly hours, any leave or time off, whether it's paid or unpaid, should be included, such as if a permanent employee takes a period of sick leave during their working hours, whether this is paid or unpaid, this needs to count towards their weekly hours. The second NES entitlement is the right to request a flexible working arrangement. Full-time and part-time employees can apply after they've been with the business for 12 months and if they meet the criteria shown. So casual employees can also request a flexible working arrangement if they've been with the business for at least 12 months, work regular and systematic hours, and there's a reasonable expectation of ongoing work. So what actually is a flexible working arrangement? It can take many forms like flexible starting times, working longer hours over fewer days, switching from full-time to part-time or casual, job sharing, working from home, or it can even be taking a period of unpaid leave by agreement. Businesses can refuse a request for flexible working where it is reasonable to do so. For example, where it's not workable for the business to accommodate the request. Now, as mentioned previously, casual employees have the employee choice pathway to becoming a permanent employee, but casuals also get the following unpaid leave. This is 2 days of carers leave, 2 days of compassionate leave, and community service leave. Now, the next few NES are going to be in relation to the different types of leave entitlements, which I'm sure most of you will have come across, but just a quick refresher on all of these. We have parental leave and related entitlements. In Australia, all employees, including regular and systematic casuals, can take unpaid parental leave after they've been with a company for at least 12 months. They can use it at any time within the first 2 years of a child's birth. Each parent gets up to 12 months off, and if you both mutually agree, this can be extended to 24 months. Just keep in mind, you can only say no to an extension if there is a valid reason. There are also a few other related entitlements you should be aware of, like unpaid special parental leave for pregnancy-related health issues, the right to transfer to a safe job or take no safe job leave if one isn't available, and of course, the return to work guarantee, so employees can come back to their role after parental leave. Next up, we have annual leave, probably the most common type of leave businesses deal with. Full-time and part-time employees get 4 weeks of annual leave based on their contracted hours. But if you have shift workers, they're likely to get 5 weeks under the Act. Annual leave rolls over year to year, and if an employee leaves the company, any unused leave has to be paid out to them. It also starts accruing from day one. So even if they're in their probationary period or just new to the role, they're accruing annual leave and there is no waiting period before they can start to take leave once they've built it up. Still on the topic of leave, we've also got personal carers leave, compassionate leave, and family and domestic violence leave. First up, personal carers leave, or as most of us would refer to it as sick leave. This lets employees take time off if they're unwell, need to care for an individual, or need to deal with an emergency. Full-time employees get 10 paid sick days a year, pro rata amount. Any unused sick leave does roll over year to year, but it doesn't get paid out when an employee leaves. If an employee takes sick leave, you are allowed to ask for proof, such as a medical certificate or a statutory declaration. Now, onto compassionate leave or bereavement leave. This is available to all employees, including casuals. Where an employee meets the criteria, they're entitled to 2 full days off. It's separate from sick and carers leave and doesn't build up over time. For full-time and part-time employees, it's paid, and for casual employees, it's unpaid. Now, when it comes to family and domestic violence leave, all employees, including casuals, get 10 days of paid leave each year. This is there to support employees dealing with these types of situations, giving them time to seek help confidentially. The leave is available right away and resets on their work anniversary each year. It doesn't roll over, and it is completely separate to annual leave and sick leave. Next up is community service leave. So some employees might need some time off for things like jury duty, volunteer firefighting, or helping out during emergencies or natural disasters. This leave covers not just the actual service itself, but also travel time and any reasonable rest or recovery after. It doesn't build up and there's no set limit. Employees can take as much as they need as long as it's for something that is eligible and reasonable. All employees, including casuals, are entitled to community service leave, which is usually unpaid except for when employees take that leave for jury duty. Okay, so we've made it to our last type of leave. This is long service leave, and this kicks in after an employee has been with the same employer for a long period of time. The exact rules vary depending from state to state. Each state has its own laws that set out how long an employee needs to work before they qualify and how much leave that they will get. For example, in Victoria, employees need to hit 7 years with their employer, while in New South Wales, it's 10 years. And it isn't just for full-time employees, casual employees in all states and territories receive it also. Now, moving on to public holidays and super. Employees are entitled to take a day off for public holidays, but businesses can ask them to work if it's reasonable. That said, employees have the right to say no as long as it's reasonable, and they can't be penalized for doing so. Full-time and part-time employees who don't work on a public holiday still get paid their usual rate of pay for the hours that they would have worked. Now touching on superannuation, all employees in Australia are entitled to super under the super guarantee laws. The NES rules on super are basically in line with super laws. So if an employer meets their super guarantee obligations, they're also covering their NES requirements. Some awards and agreements might have extra superannuation provisions, so it is always really important to check those. Okay, so now moving on to our second last section of the NES. This is one of the more comprehensive entitlements, which is notice of termination and redundancy pay. So we're going to go into this in a bit more detail, as it's probably one of our most asked about areas from clients, and understandably so, because it is particularly tricky to navigate. So firstly, we're going to start with the notice of termination. This regulates the amount of time an employer needs to provide to an employee when ending their employment. The Fair Work Act and the NES are specifically set out to deal with the notice that an employer must provide, not an employee. However, modern awards, EBAs, and contracts will often outline the requirement for employees to provide notice when they resign. We have on screen the notice periods outlined in the Fair Work Act, which are the minimum periods employees need to receive if the business wants to terminate their employment, which, as you can see, is based on their length of service with the business. Importantly, an additional week's notice is provided to employees over the age of 45 with at least 2 years service. These figures shown are just the minimum amounts within the NES. Modern awards and contracts can provide for a longer notice period, so it's really important to check to ensure that you're providing the correct amount. For example, despite the notice, an employee that is covered by the Professional Employees Award, they will be entitled to 1 month of notice, so even from their first week of employment with the business. Furthermore, it's quite common for employment contracts to include longer notice periods, specifically for managerial positions. If an employment contract provides for that longer period than the NES, this will take precedence and the business could not then revert to the minimum requirements, meaning the longer notice period that's stated in the contract is going to be provided to that employee. Now, businesses have the option when providing notice to either have the employee work this out or make a payment in lieu to the employee. Where the business decides to pay the notice instead of having the employee work, their employment will cease on the day the notice is paid to the employee, meaning they would not need to work this period. I'm going to touch on this quickly as it is quite often misunderstood, but if a business has opted to pay notice in lieu to an employee, the payment must be made on the day of termination and the day that's meant to take effect in order to comply with the Fair Work regulations. So, for example, the business can't terminate an employee today and inform them that they'll be paid their notice in lieu next week. If a business is terminating an employee today, their notice in lieu would also need to be paid out today. There is the option of placing an employee on gardening leave, which is where they're still employed, but they're placed on a period of paid leave. However, the ability to do so is determined by whether or not your employment contract provides for this option. So keeping in mind that anytime you're providing notice to an employee, this has to be communicated in writing. Again, it's not technically correct, although it's really common to verbally inform an employee of their termination end date and then following up at a later date in a written letter. However, this should be provided either in that termination meeting itself or immediately after. The notice period provided to your staff will commence the day after the business signals the intent to terminate. Notice is not going to be relevant for all of your staff, as not all staff are entitled to receive notice periods. So this will include casual employees, fixed-term employees, and employees who are terminated due to serious misconduct. We do often get asked about serious misconduct, so touching on this point briefly, and its meaning under the Act, it's generally reserved for the most severe examples of misconduct. It's misconduct that poses a significant and immediate threat to the business's viability, profitability, reputation, or the health and safety of individuals within the workplace. The threshold for serious misconduct is exceptionally high, considering it's one of the harshest penalties a business can impose on an employee. It generally involves actions that are willful and deliberate and are inconsistent with the continuation of their contract, resulting in a summary dismissal, which is a dismissal without notice. This can include actions such as theft, fraud, assault, intoxication, and sexual harassment. Again, it is an exceptionally harsh outcome given the nature of these types of conduct. So if you're uncertain whether your situation would constitute serious misconduct, it's always best to seek further professional advice. If the dismissal does not meet this threshold or they're terminated for other reasons, then eligible staff will need to be provided with notice upon termination. Now, on to the second half of this entitlement, we have redundancy pay. This is an additional payment provided to certain employees where they have been terminated due to a genuine redundancy. Importantly, this is a completely separate entitlement to notice requirements and is an additional payment that needs to be made when it's applicable. We have the table outlined on the screen for reference, but the amount payable is based on the employee's length of service. However, not all employees are eligible for redundancy pay. Typically those with less than 12 months of service, those who are on a fixed term contract, casual employees, trainees, apprentices, and employees terminated because of serious misconduct will all be exempt from this type of pay. In addition to this, under the Fair Work Act, small businesses, which are businesses with less than 15 employees, are generally exempt from paying redundancy pay. But this is where it's exceptionally important to always check the modern award, EBA, and contract, as these can provide for more favorable provisions for employees. So whilst the general majority of these will align with the Fair Work Act, some do provide for much broader entitlements, or what is referred to as an industry-specific redundancy scheme. One of the most commonly overlooked examples of this is the Building and Construction Award. Under this award, the basic NES provisions for redundancy are replaced by an industry-specific scheme. This includes a particular definition of a redundancy which is different to the NES. Under this award, a redundancy is a situation where an employee ceases to be employed, except in cases of serious misconduct or refusal of duty. So that means that the redundancy pay provisions within this award are going to apply even when the employee has resigned or been terminated for any other reason. Also, unlike the NES, employees in the building and construction sector with less than a year's service may still qualify for redundancy pay based on their completed weeks of service, and small businesses are not actually exempt from this type of payment. Okay, so you'll be glad to hear that we are on to the last entitlement of the NES, which is short and sweet. It is actually the Fair Work Information Statement and Casual Employment Information Statement and Fixed Term Information Statement. So this has been previously discussed. However, it's just important to note that these do form part of the NES, and you are required to provide this to your staff when they do start. So that is now a wrap for the NES. So just a quick summary of all that we've covered. There are 12 key areas ranging from leave to termination entitlements, and these form the very minimum entitlements that employees receive. I'm going to now pass you back to Annie, who's going to delve into breaking down the complexities of modern awards with you.
Brilliant. Thank you, Lorna. Definitely a lot to take in there. So a lot to cover and be aware of. So again, another point on modern awards and classifications, which we're moving into now. So throughout our webinar today, this consistent point around knowing your relevant award has kind of come up, or knowing your relevant legislation has come up quite a fair bit. So this is one of the most important aspects of when you're employing a staff member, as it's going to underpin a huge amount of their entitlements and your obligations as an employer. We often come across this misconception that simply paying someone a substantial wage or more than the market rate nullifies the necessity of ever going through an exercise of if there is a relevant modern award that applies to them, but that can be quite a risky approach to take. If we cast our minds back to the start of the webinar, we had that pyramid diagram on the screen, and we had the Fair Work Act provide, some basic entitlements, which Lorna went through. But as you may notice, these are very broad, sweeping entitlements that all employees should be receiving, but they're not really specific to certain industries or roles. The purpose of modern awards is to sit on top of this and provide more comprehensive entitlements and detail that take into account the particular aspects of a certain industry or role. They're very comprehensive. Anyone who's looked at them, they're very lengthy documents. That's because they cover a really broad range of things like classifications and pay levels. They do allowances, penalty rates, overtime, even other things like the hours of work that an employee can work, leave entitlements, even annual leave entitlements in certain industries as well. So as you can see, they cover more than just simply what someone is being paid. So employing staff with absolutely no reference to a modern award can be a huge blind spot for an employee, for a business to take, and can lead to, the potential of an underpayment claim arising. We've had a couple of examples of this. We have the Building and Construction Award, and it has its industry-specific redundancy scheme, the Professional Employees Award, and having that 1 month of notice. In both those examples, a business that was operating on the proviso that they paid a rate and it was fair, and they just don't ever have to reference that legislation, would, of course, not be accounting for that additional entitlements and be assuming a fair bit of risk. So I suppose the next point is then, how do we know what modern award applies, or how do we make that kind of analysis? So let's take a bit of a deep dive together on what a modern award is and how to kind of determine coverage. So modern awards are legal documents that cover certain industries or roles and provide additional employment entitlements for staff. There are 121 different modern awards in Australia, all of which have a different scope of coverage for who they're intended to actually apply to. Largely, they're divided into what is called industry awards and occupational awards, although just to complicate things, there are a handful of awards that are both, but mostly they're divided into those sectors. We're going to cover the difference between these two because it's the kind of the Kickstarter to navigating what award is going to apply to your business. So starting off with industry awards, these have the broadest range of coverage. It applies to an entire business that operates in a certain industry. For example, employers in the retail industry, so that could include, for example, a shopfront, are likely going to be covered by the General Retail Industry Award. This award has a very broad range of roles, so it can cover everyone from sales assistants to stockhands, even some tradespeople like bakers, and even admin staff that perform clerical work at that retail shop. However, not every business kind of falls in a field that has an industry award that applies, or it might be the case that not all their employees are described in that award. In that case, we can look at sometimes occupational awards. These have a much narrower scope as they're meant to be specific to a role or kind of duties that are being performed. One of the most common examples that a lot of you have probably come across is the Clerks Award, which is specifically for employees engaged in clerical or admin work in the private sector, and only when, of course, they aren't covered by an industry award. Keep in mind that when your staff is covered by a modern award, you need to inform them of this and provide them with information on where to reference this. So very important to obviously know what modern award applies to them for that purpose as well. One question that often comes up when we're talking about modern awards is, can someone have multiple awards apply, or is it just one? The answer is yes, multiple awards can come up. This is quite a common occurrence, although it can be a little bit tricky to determine when there's multiple applying at the one time. They could have, for example, multiple occupational awards that cover a wide variety of different roles, or they could have an industry award and occupational awards. It can be a bit of a mix. Employees, though, usually are going to be covered by a singular award that's most appropriate for their role. I'll go through a bit of an example shortly on how award coverage works, and we'll go through kind of a worked example of figuring that out. So modern awards will usually contain what is called a coverage clause. That describes the scope of the award as well as who it might exclude. However, simply falling in that scope doesn't mean that the employees are actually going to be covered. The next step is to check if it's the right award by looking at the classifications and does it describe the type of work your employee is doing. The classifications are usually at the very end of the award, and they're going to describe the different types of work and employees that it can actually capture. These are usually divided into different levels, which correlate with certain levels of pay. Each level will describe different sets of tasks, qualifications, experience, and skills for an employee to be classified at that level and thus fall within the scope of that award. Some awards, admittedly, are very easy to read. Some are a little bit harder to make that determination, but the purpose of classifications is to serve as a guide to employers on exactly who can fall within the scope of that award. Now, often I see employers trip up on this myth that paying a higher rate means you don't have to worry about classifications and you can just, go as is. Classifications do dictate an employee's minimum entitlement, so their minimum rate of pay under that award. So to make sure you're actually paying someone high enough and that you're solid, that you have offset that amount, you have to know obviously what minimums you're working with and be ready to calculate those when available. Even further to this, most modern awards have an outright requirement for employers to inform their staff of the classification which they fall under that award. So having not gone through that exercise does risk breaching that obligation as well. So we're going to do a bit of an example here. In this example, we have a building company, very original name for a building company that primarily builds residential houses. They mostly employ on-site trades, but have one admin assistant that's actually working from home. So let's start with industry awards. Remember, that has the broadest scope. So the likely award we're working with here is the Building and Construction Award. On the screen, I've gone and summarized the coverage and also highlighted what helped with that determination, as it is a little bit more long-winded in terms of coverage. But as we can see, it does capture the type of work that they're doing. Remember, our second step is to look at the classifications. We look at the classifications. It does describe outright a whole range of trades. So we've got our brickies, laborers, roof tilers, and scaffolders all captured. Now, what we're not finding here is that, it can capture a admin assistant that isn't working on site. It doesn't have that scope for us. So what we're going to have to do is have a look at some other awards and see whether we can place that admin assistant elsewhere. So we have our coverage for our on-site trades. We're looking for that final employee. Knowing they fall in the industry of building, we're not looking at other industry awards, but what we are looking at are perhaps some occupational awards. And the one that we're coming up against, which we mentioned before, is the Clerks Award. Again, the definition is on the screen for everyone to have a little read over, but we can see that it covers employees primarily engaged in admin or clerical work, which in our example, our admin assistant is doing. To keep with step 2 being the classifications, if you read through them, we have an array of admin tasks that are described, which are also going to apply to our employee as well. So with that, we can obviously make that conclusion that we have 2 awards applying to our building company in this scenario. We have the Building Construction Award, and we also have the Clerks Award. So 2 awards at the same time. However, obviously, what would happen if we just couldn't make a determination on the award, or there's nothing that seems really relevant for us? So before you jump to that employee being award free, we need to consider whether the miscellaneous award will apply. This is what they call a catch-all award, very general. It's meant to capture roles that might traditionally have fallen outside of the award system. It does have some exceptions, though, detailed on the screen. So managerial employees and professional employees are excluded from their coverage. But just as some examples of businesses that might not have an industry award or occupational award, but do fall in the miscellaneous award, are tattoo artists working at a tattoo shop usually, and pet groomers working in a pet grooming business are examples that Fair Work have put out there before about employees that fall outside of the industry and occupational awards, but do fall in the miscellaneous award. Now, where we can't find any awards apply, industry, occupational, and the miscellaneous isn't applicable, that's when we move to them being award free and we make that determination. Their entitlements then will just derive solely from the Fair Work Act, which Ilona went through that NES for us, and the terms of their employment contract, but they won't have those additional modern award entitlements like overtime, penalty rates, and all that hours of work. Now, we often get asked, can you just opt out of the award system and just not have it apply? Whilst you can, to some degree, alter how the terms apply of a modern award using an IFA, and it's limited what you can sort of maneuver, it's not to say that that means it doesn't apply to your staff. If there is a modern award and has scope of coverage for your employees, it will apply whether you have recognized it or not. So ensuring that you have accounted for the right entitlements and are paying staff correctly will mean that you need to know what modern award and their classification is to be able to make that determination. An important point on this is, as some of you might be aware, the legislation around underpayments has changed significantly with the Closing Loopholes Act that was passed last year. And that really highlights the importance of being aware of your obligations. At the beginning of this year specifically, we saw some really important changes come into effect, especially around the criminalisation of wage theft, which came into effect on the 1st of Jan. This change now means that employers can face criminal charges, which could include heavy penalties or even jail time for deliberately underpaying their staff. Importantly, those penalties that you can face apply to a company themselves or can apply to individuals that were engaged in that deliberate underpayment. So that could be HR managers, a business owner, or senior managers. On the screen, I do have the potential penalties that these can involve, but as you can see, very significant and extremely significant payments, penalties that they can include. What I want to reiterate with the criminalisation of wage theft that we see come up quite a fair bit is that this is to target deliberate and intentional underpayments. So it's not meant to capture honest mistakes that might happen. It's meant to target that kind of small, minute amount of employers that are genuinely doing the wrong thing. However, of course, going through this exercise, the purpose of making sure you are aware of your obligations is to just not put yourself in a position where you have to prove it was a genuine mistake and not a deliberate mistake, by kind of being proactive in your approach. Another thing is, it's not to say that having made a genuine mistake doesn't have any repercussions. There are still extremely high penalties for these contraventions. And this is also another area which the Closing Loophole Act did make some changes in. Again, I have the relevant penalties on the screen, but as we can see, they are also quite significant as well for unintentional breaches. What I think is kind of clear from the Fair Work changes that we've seen come in is that they intend to take a much harsher approach with businesses around potential underpayments. And what I think this highlights is that this approach that may have historically happened around casually kind of employing staff with, just on a trust system and a handshake agreement, and you kind of hope that they're paid fairly, isn't something that's going to fly exactly moving forward. The onus on employers and the expectations are a lot higher. And there's this need to kind of self-educate and engage with your obligations proactively to ensure that you are actually compliant. Often this can be very overwhelming, especially if you've never looked at this space or you don't have a lot of resources in this space. So one of the best starting points that I often reiterate to clients is to look at modern awards and classifications as a starting point, as they do underpin so much of your employees' entitlements and so much around your obligations. So if you don't feel confident in navigating your awards, that is something to usually reach out and get some professional guidance on. But I do often point to those areas as a good starting point. Now, closing us out today, I am going to hand it back to Lorna, and she's going to go through some contracts and policies to hopefully apply everything we've gone through today. So we've gone through legislation, we've gone through employment types, modern awards and classifications, now need to, at the point of actually applying these into practice, which involves looking at your contracts and policies. So Lorna might take us through this in a little bit more detail and see how we can do these right.
Perfect. Thanks, Annie. So let's do a quick recap. At this point, you may feel pretty confident that you know about choosing the right employment type, understanding the NES, and figuring out the award and classification coverage. And with this information, you'll be ready to make an offer of employment to a new employee. So once you've reached this stage, which is always very exciting after going through a recruitment process, you're going to want to formalize your agreement and employment offer to the candidate. And the best way to do this is through an employment contract. So what exactly is an employment contract? It's basically an agreement between you and your employee that lays out the terms and conditions of their employment. Most often, this will be a written agreement, although it's not legally required, it is extremely recommended. Whilst verbal agreements can still be valid and are of course binding, they leave much more room for misunderstanding and can be extremely difficult to demonstrate if there is ever a dispute. A written contract will outline exactly what was agreed upon when the employee commenced and the agreed terms of their employment, which can be a really positive way to kickstart their employment and ensure you're minimizing future risk. So now that we know what the employment contract is and the benefits of having one in writing, we get a lot of queries around the content of an employment contract. Essentially, the contract should spell out the key terms of employment and any extra responsibilities the employee needs to follow. This includes things like their employment type, salary, working hours, location, and even how much notice they need to give if they do decide to resign. It usually will also be necessary to have in a contract if you're seeking to place additional restraints on your staff's employment, such as ensuring they keep company information confidential or that they do not go to go work for a direct competitor. Without these types of clauses in a contract, it can be extremely difficult to enforce these obligations or to seek legal action if something like this does occur. A contract can also be important if a business wants to pay a salary or a rate that is meant to encompass a range of their award entitlements, like penalty rates, overtime, or allowances. Generally, this is covered by what is referred to as an offset clause, and this essentially outlines that their particular rate is meant to absorb these entitlements. An obvious caveat to this is that, of course, the rate of pay does need to actually be high enough to compensate for these entitlements. That means they cannot be paid less in any given week or period what they would have otherwise received under the award if they were paid these separately. Now, contracts also help businesses to meet some basic legal requirements. For example, as Annie mentioned, you need to let employees know if a modern award applies to them and what classification they fall under. And the easiest way to do this is through the employment contract. Another one of the most common questions we get is, why do you need both contracts and policies, and what are the differences between them? Whilst contracts set out the agreed terms of employment, policies set out the ground rules and processes for your business. They spell out what's expected from employees, including how they should be conducting themselves at work. They're a guide for employees on things like how to request leave, what attire to wear to work, and what to do if they need to raise a grievance or a complaint. Having these policies in place helps your team to understand what's expected of them, and they also lay out what happens if someone doesn't follow the rules, such as disciplinary action. Generally, policies should sit separate from your contract, given they're quite detailed documents, and so it allows the business to continue to improve upon them, and you can edit them from time to time as needed. What is extremely important with policies is to reach that perfect match between being detailed, but also allowing for some flexibility. For example, a policy that strictly requires 2 written warnings before termination might actually make things harder to manage, especially since different situations call for different responses. Instead, policies should set guidelines and processes while still giving the business some room to make judgment calls when needed. Policies also play a big role in making sure that your business meets legal requirements. We have these on the screen, but this includes for example, all public companies and large proprietary companies must have a whistleblower policy. In New South Wales and ACT, if you're planning to monitor employees' emails or internet use, you legally need a workplace policy in place, surveillance policy in place. Another big one is a privacy policy, which covers how your business collects, stores, and shares information. This is compulsory for businesses with an annual turnover of $3 million or more. I would also put a major emphasis on a bullying, discrimination, and sexual harassment policy, as there is a positive duty on employers to eliminate workplace sex discrimination and harassment. Employers can actually be held liable for conduct involving harassment in the workplace if they have not taken appropriate steps in prevention or do not appropriately respond when they're made aware of such conduct. Again, if there are policies that you do need help with, this is something that our team can definitely assist with. But for today, that fully wraps us up. I'm now going to pass you back to Annie, and we'll see if we have time to go through some of the questions that have come in.
Brilliant. Yes, I know we did go through a fair lot today. I can see there's quite a few questions covering a whole range of different topics. So we probably won't be able to get to everything, but do remember we will follow up with an FAQ going over some of the questions that we haven't gotten to. So we might go through a couple that we have time and can squeeze in with what we have left. One I saw that came through that I thought was particularly interesting, I think it was from Teresa, and it was making comments around family and domestic violence leave and what you can show on a pay slip. And I know we didn't touch on pay slips, we just kind of touched on the entitlement, but that is a very important factor for family and domestic violence leave, particularly something to draw your eye to is that they do have particular requirements around what you can show on a pay slip, because obviously the impact that could have on an individual using that type of leave. So usually you cannot show on a pay slip that they are taking family and domestic violence leave. You have to show it as a different type, usually as an ordinary hours, bonus, or allowance. There are particulars on the Fair Work website on how you should manage this in your pay slips, but just be very aware if someone is utilizing that type of leave to not automatically be putting it as family and domestic violence leave on their pay slip. Make sure you're discussing this with them and showing it as a different type of payment. So you're recording it, but not as that actual payment.
So another one that we got through is, if employees are covered by an EBA, do we need employment contracts also? And yes, you do. So EBAs are similar and comparable to modern awards. So you still need to have your employment contracts in place, or would be highly recommended.
Brilliant. Another one that we got through that I thought was a good question was, if notice is paid out, how do you determine what their official date is? Is it the day that it's paid out, or is it the future date? Say they had 2 weeks, is it 2 weeks from now? If you've made the decision to pay the notice in lieu to the employee, their employment ceases on the day. So it ceases that day and you're paying that amount to them. So you don't set their notice date as 2 weeks in the future. You set it as, say, today, and you've made the payment then for that 2 weeks. So the official date that you're recognizing is the day you've given that notice.
Okay, and another one that we got through is someone asked, is personal and carers leave the same thing? Yes, it's the same entitlement. So personal leave is sick leave and carers leave is carers leave, but they come under the same entitlement.
Awesome. I think probably just the one last one for today that I saw, which was around employment contracts and notice. And the question was, can the notice period in employment contracts be greater than what is the minimum? And the answer is yes. And that's really quite common. You'll see it for managerial roles and you'll see it for certain roles in the business that say the minimum under the NES is a week. They've only been there less than a year. You could have in their employment contract a lot longer. For managerial roles or say senior staff, it's not uncommon to have a month of notice, or even sometimes for very, very senior roles, a couple months of notice. But you might just recognize the minimum if that is relevant to that employee. You kind of base that on what you need from them and how difficult it's going to be operationally to replace that role. So you might gather for more senior roles or more technical fields, take a bit longer to fill that role. You might have a different notice period in there that's greater than what the minimum is. Right, I think we might wrap it up for today. If we didn't get to your question, just a reminder, we will follow up with an FAQ. Going to follow up with the slides as well, a recording and a couple of resources. We did cover a lot today. It's a very ambitious agenda. Thank you, Lorna, for going through it with me and for taking us through the NES and for taking us through contracts and policies. If you have any questions, please reach out to our team and see how we can help you outside of our service today. At the end of this webinar, there will be a brief survey. We'd love to have your feedback if you can take a minute to fill that out. But other than that, I hope everyone has a good day and I hope to see you in our next presentation. Thank you, everyone.
Thanks, everyone.